in order to for that case to go forward. Excuse me. So once again, thank you for attending, and I hope it's I hope it's entertaining, but if not, I hope it's certainly educational. It's not often that you'll have this ability to actually see a Supreme Court oral argument. So thanks.
Thanks, Chief. Let's give him a big round of applause. He doesn't get applause on the bench very often, so we'll give it to him tonight. So again, we'll be in session here shortly when the justices approach the door over there. Again, our honorary bailiff, again, when he raps that gavel 3 times, please rise as the court enters the courtroom.
Ladies and gentlemen, the Honorable Justice of the Supreme Court, hear ye, hear ye, hear ye. I figured they'd know better. Okay. As soon as I get there. Okay, all persons having business before the court, you're admonished to draw nigh, give your attention to the court.
Please be seated. Good evening. I am Chief Justice Marla Lukert, and it is my pleasure to welcome you to this evening's special session of the Kansas Supreme Court. We are so excited to be in Great Bend and to welcome all of you to our hearing today. It's our opportunity to give you a chance to watch the Kansas Supreme Court hear actual cases, and to provide you a chance afterwards to visit with us and the reception that will follow. This is part of our effort to make the Kansas Supreme Court accessible to Kansans. We have turned a Beach Boys song into our Supreme Court on the Road theme song. So you might hear us humming "Round, Round, We Get Around." We try to do this a couple of times a year where we leave Topeka and visit a Kansas community. We do the court at night so that people don't have to have work or school conflicts, and it's easier for you to come out and watch an appellate argument, which few people really have the opportunity to do because it's so difficult to get away from the demands of your life and come to Topeka to hear our regular hearings, all of which are open to the public. And I would also mention that all of our arguments are also available on our YouTube channel. So at any time you can watch a live argument or go back and listen to an argument from a past case that you might read about and be interested in. But here we are tonight as we're getting around and have had a wonderful day of visiting in the area. You may not know that there are 31 judicial districts in the state of Kansas. The geographic size of those districts varies from several of our districts are just one county. Those are usually our larger urban metropolitan areas. And our largest number of counties in a district is we have one district with 7 counties. You may know or may not know, our Great Bend is in the 20th Judicial District, and that consists of the counties of Barton, Ellsworth, Rice, Stafford, and Russell counties. So today, justices have been busy visiting with the staff in many of those courthouses and talking to our hardworking court employees who are your neighbors that help keep our courts running every day. And you saw many of them out in the foyer greeting you as you came in. We all, as Kansans, owe them a huge debt of appreciation for their excellent work and what they do. We also today have been out and about at various schools. Area judges have joined us in that effort. We visited 6 schools. We borrowed Chief Judge Bruce Gatterman, who is from Larned, and which is in the 24th Judicial District. But he helped us out so that we would to make those visits. And we actually went to Larned, one of our justices with Judge Gatterman, to speak at the high school there. But to your local judges from the 20th Judicial District, Chief Judge Johnson and Judge Lisa Baran from Barton County, Judge Richard Burgess from Rice County, Judge Carrie Hipp from Ellsworth County, and Judge Timmery Walters from Stafford County joined us as justices spoke at Barton Community College, the high schools in Great Bend, Hoisington, and Ellenwood, and at Central Plains High School in Claflin. We estimate that we reached 775 students today. And so we hope we have left them with a better understanding of their government and the role of the courts in that government. We want to express our gratitude to the judges who helped us with that, as well as the judges and the court employees who have helped us with the planning of today's events and this evening's programming. Also, a special help to our own staff, the Office of Judicial Administration in our court, who has spent a great deal of time making all of these events work really, really well. So we appreciate that. You may have seen several law enforcement officers around that are providing security tonight. And I also want to extend a special thank you to them. The Great Bend Police Department and the Barton County Sheriff's Office have been stupendous in helping us, really gone above and beyond. We've also had the assistance of the Kansas Bureau of Investigation, the Kansas Highway Patrol, and teams from Crisis 24. I now move to giving my gratitude to Tom Burscheit, who is our honorary bailiff who opened court tonight. Some of you may know Mr. Burscheit. Mr. Burscheit is a long-serving attorney in your community for about 57 years, I believe. And 54, see, it seemed like that. So we all consider Mr. Burscheit to be one of the pillars of our profession. He has given back in many, many ways, not just in your local area, but across the state. We are a self-policing profession, both with our judicial discipline and our attorney discipline. And Mr. Burscheit has had an integral part for decades in helping with that attorney discipline. So he's also seen as one of the best mentors to young attorneys in the area. I've heard expressions of how grateful people are to what he has done. And not all cases end up in litigation, but many cases are settled, often through a process called mediation. And Mr. Burscheit has been very active in that part of our profession as well. So we are delighted to have him and to be able to honor him tonight with asking him to be our bailiff. So thank you, Mr. Burscheit. So finally, as you may be saying, this brings me to tonight's proceeding, which will give you a chance firsthand, as I said, to actually see us interact with attorneys on real cases that are being brought before us. Gives us an opportunity, we hope, for you to understand better how our court makes decisions. Before tonight, we have reviewed the record in the trial that will be the subject of our first case, and the documents from the federal proceedings that will be the subject in our second case. The parties have presented us with written briefs in which they've cited laws. Those may be the US Constitution, the Kansas Constitution, and statutes passed by our state legislature. And they may also be court decisions from our court or other courts that are called what we refer to as precedent. And we follow precedent and we follow those statutes. In terms of the statutes and the Constitution, we don't evaluate whether those are good policy. That is the job of the legislature as they write those statutes, and that is the job of you as the people as our Constitution was written or amended. Our obligation is to take that law and apply it. We set aside our personal beliefs, politics, special interests, and even public opinion. That means, for example, that tonight we are not going to do a public opinion poll or ask you to tell us how you think the cases that we are hearing tonight should come out. We have to remove ourselves from those influences because our job is to maintain fair and impartial courts for all Kansans. As Thomas Jefferson said about 200 years ago, the most sacred of the duties of a government is to do equal and impartial justice to all its citizens. And that's what we're about tonight and every day when court is convened in Kansas. So we hope you leave this evening with a better understanding of the contributions of the lawyers who will argue the case in helping us frame that law and in helping us further the rule of law. Finally, before we start, I would like to take just one more moment and introduce my colleagues. I'll first tell you that we do represent or come from the entire state, really. I grew up in far western Kansas in Goodland. And I will introduce the other justices in the order of the length of time we have served on the court. Justice Eric Rosen hails from Topeka. Justice Dan Biles grew up in El Dorado. Justice Caleb Stiegel is from Lawrence. Justice Evelyn Wilson grew up in the Smith Center area. Justice KJ Wall grew up in Scott City, and Melissa Taylor, Justice Taylor at the end, grew up in Lawrence. So as I said, we do come from all areas of the state. We'll now turn to me asking the clerk of the Kansas Appellate Court, Mr. Doug Shima, to do the honor of calling tonight's docket. Mr. Shima?
Thank you, Your Honor. May it please the court. The first case on the docket for Wednesday, April 6th, 2022 is appeal number 323, State of Kansas versus Rachel C. Hilliard, Sedgwick County, briefs both sides. Council will approach the lectern and enter your appearance.
Your Honor, my name is Randall Hodgkinson. I'm appearing this evening on behalf of Rachel Hilliard, and I'm ready for argument.
Thank you, Mr. Hodgkinson.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Thank you, Mr. Maloney.
The second case on the docket is appeal number 124415, Mark Bruce versus Laura Kelly in her official capacity as governor of the state of Kansas, William Lawrence in his official capacity as chief of staff to the governor, and Herman T. Jones in his official and individual capacity as superintendent of the Kansas Highway Patrol. This is a certified question from the federal court. Brief both sides. Counsel will approach the lectern and enter your appearance.
Please the court, my name is Alan Johnson and I represent Mark Bruce, the plaintiff in the case, and I'm ready for argument.
May it please the court, David R. Cooper appearing on behalf of the governor, the Honorable Laura Kelly, Chief of Staff Will Lawrence, and Colonel Herman T. Jones of the Kansas Highway Patrol. Present and we're prepared to present argument.
Thank you, Mr. Huber.
Your Honor, we're ready for argument.
Thank you, Mr. Shima. Would counsel on the first case please come forward? 123323. Mr. Hodgkinson.
Good evening, Your Honor. My name is Randall Hodgkinson. I'm appearing this evening on behalf of Rachel Hilliard, and I request 3 minutes for rebuttal.
3 minutes is granted. Thank you.
Your Honor, you will remember this is a first-degree murder case out of Wichita, and as was sort of briefly described before the court came in, this case involves what we can all acknowledge are tragic circumstances resulting in the death of Mickey D. In this case. And my client was prosecuted and convicted of first-degree premeditated murder and sentenced to a hard 50 sentence, which I did math before I came in, which means she would be eligible to see the parole board if she lives 50 years in prison at the age of 86. Your Honor, and I just want to acknowledge sort of at the beginning the sort of the graphic and shocking nature of this case, and that we know in this profession that this court gets the first-degree murder cases. That's the jurisdiction of this court. And so it's not infrequent, but it can be very shocking to people who don't see this kind of work every day. But at the end of the day, this case, just like all cases that come before this court and every court, is about whether or not every person that comes before the courts in Kansas has gotten their day in court, a fair day in court, and a fair day in sentencing. And the record and the briefing in this case reveals that my client got neither. I raised 5 issues in this case, Your Honor. One issue about sufficiency, one about instructions, one about postural error. But I think the standards of those issues are pretty well settled, and the record is the record. So I plan to speak mostly about issues 3 and 5, which have to do with my client's appointed attorney asking the jury to find her guilty, and also the failure of the district court to engage in a mental evaluation of my client before sentencing her essentially to die in prison. But I'll pause because of course I'm here to answer the judge's questions, and maybe you want to talk about something different. But issue 3 in this case has to do with my client's appointed attorney in this case engaging and entering a guilt-based defense in this case. Your Honor, we all know that as defense attorneys, sometimes it's our job to counsel our clients, and it may be our job, our very reasonable job, to counsel them to maybe plead guilty in some cases. That if clients charged, your best avenue here for some clients would be maybe you'll get a reduced charge or a sentencing recommendation, so you should plead guilty. Or sometimes we have cases where we're going to go to trial, but maybe we would want to plead guilty to one of the charges, maybe a lesser charge, sort of take it off the table. And again, that might be a reasonable trial strategy to say, let's take this off the table.
Clarify, Mr. Hodgson, if your client consented to the guilt-based defense or not. It doesn't appear in your brief you really acknowledge that she did or didn't.
There's nothing in the record showing that my client consented to a guilt-based defense. And that's why I'm showing, we have these other examples, and we have a more recent example of even when a client decides maybe to stipulate to one element of the offense, which again is reasonable, typically for criminal possession of a firearm. Maybe we want to stipulate to that element because we don't want all the details of that coming before the jury as they're deciding that crime. In this case, the attorney argued and asked the jury to find my client guilty of a lesser homicide. Now that might be, again, a reasonable trial strategy. I don't know, I'm not saying it is in this case, but it could be. But here's the thing, in those three other examples that I gave you, it's very clear, and this court has made it very clear, if that client's going to plead guilty or stipulate even, partially plead guilty, there has to be a record made that that's the client's decision. Because almost all the other decisions at a trial, the trial attorney gets to make. If I'm defending somebody at a trial, I get to decide what witnesses to call. I get to decide what trial strategies to make. Generally, I get to decide what instructions to request. But my client is the only one who can say anything but I'm not guilty.
What do we do with the fact, counsel, that your client voluntarily testified and admitted to her guilt on the stand?
I would take issue. I do not believe she testified that she was guilty. She admitted that she was involved in an altercation with the decedent in this case.
I thought she testified for the reason why she did what she did.
She testified that there was an altercation and that the decedent fell and was unconscious. And in fact, my client believed that she was already deceased at that point. And then testified as to hearing the voices in her head telling her that she needed to remove the decedent's head so that the decedent's soul could go to heaven.
But there's no indication.
That's not an admission of guilt, Your Honor. That's not an admission of guilt.
There's no indication at any point in the trial that she argued or resisted the suggestion that that she may be guilty of something. Is that significant?
It's not significant in any of those other cases, and so I don't know why it would be significant in this case.
In the other cases, they did argue with it. I mean, one stood up and said, I never agreed to that.
Mr. Carter
I'm
did.
innocent. And in the others, there was some indication that they were objecting somewhere in the record, and there just isn't anything here that would indicate that she didn't talk to her attorney and they worked this all out off the record.
I'm sorry, I didn't understand your question, Your Honor. When I was talking about the other cases, I was talking about in the case of a person who pleads guilty, or a person who pleads guilty to one of some count, or even in Johnson, when a person stipulated to one element of a crime. There was nothing in Johnson that Mr. Johnson said, I didn't want to stipulate to that crime. But this court said correctly that before we're going to allow and recognize a person to have waived their fundamental right to a jury trial and due process, we need something on the record that we know that's the client's decision and not just the attorney's decision. And that's not present on this record.
Was there anything in the record about her testifying period? Did the judge ask her any questions about testifying?
I don't remember any questions about testifying one way or the other, Your Honor, but it's not my fault, but I don't remember that. Maybe my colleague will remember. So it's our position that given what this court has said and what other courts have said about this decision, that a guilt-based defense may be a very reasonable defense, but, and this is why I think this issue is coming up now. I mean, the United States Supreme Court just a few years, 4 years ago now, and McCoy clarified that a guilt-based defense has to be a client's decision, has to be their affirmative decision, and it's the decision that they get to make. That I could go to that client and say, look, your only chance here, client, is we need to try to get a lesser offense here because I just don't know what else we're going to do. And if my client says, no, that's not okay with me, then my job as a defense attorney is to say, okay, then we're going to go to trial and I'll do what I can. And the logical conclusion of, in Johnson, if it's true, and it is, that if a client's going to just even partially waive their right to a jury trial, you need an affirmative showing on the record that that's the client's decision. Why wouldn't that be true for a guilt-based defense like this? So we would ask that you No, sorry, Your Honor. We would ask that you hold, and I'm not even asking you to extend, to apply Johnson and McCoy to the logical conclusion that in order to have a guilt-based defense, for an attorney to use a guilt-based defense, there needs to be some affirmative showing on the record. Mike, go ahead.
What actually happened below that constitutes what you're describing as a guilt-based defense?
When the attorney told the jury an opening statement, at the end of this case, I'm going to ask you to find my client guilty
Of the lesser?
of a lesser offense.
Okay. So, but it's the attorney's arguments to the jury.
Yes. The affirmative request to the jury of that, yeah.
And if that statement to the jury is consistent with the evidence, is that the same as waiving your right to a jury trial on the element? And it circles back to Justice Standers' question. Your client did testify that she killed the victim. And that may not be the same as pleading guilty, but it is strong evidence that fits the elements of the crime.
Your Honor, my client testified that there was an altercation and that the decedent died as a result of the altercation. But not every time that a person causes somebody's death, it's a homicide.
Right.
That's not a fair
And that goes
conclusion.
directly to my question. Why can't the defense lawyer make the best argument to the jury available to that lawyer based on the evidence? In other words, why isn't it just an evidence-based argument as opposed to a waiver of the client's constitutional right to a jury trial on that element?
Because McCoy and this court in Carter, who presaged McCoy, said that's a fine argument, that it may be that the evidence best fits that, but that's not going to the jury and telling them my client's not guilty. That's what my client's day in court is having somebody go there and go to that jury and say they're not guilty unless that client says I'm waiving that right, and they have to do it explicitly.
How McCoy works for you, because as near as I can tell, the exact language from McCoy is that the client, the defendant, has to make an intransigent objection to the lawyer's admission. And you don't have that in this case.
So it's combining McCoy and Johnson now, because what we know from McCoy, what we didn't know before McCoy, we had a pretty good idea from Carter in Kansas, but what we didn't know is, can a lawyer run a guilt-based defense over the objection of the defendant? Before McCoy, we didn't know that for sure from the United States Supreme Court, and now we do. We know that if the defendant doesn't affirmatively consent to the running of the guilt-based defense, the lawyer can't do it under the Sixth Amendment right to counsel.
How do you get the consent with the court's language, which is an intransigent objection from the client to the admission? I mean, that's something different than just whether the defendant consents to this.
I'm putting it together.
In both cases, the defendant's jumping up and down saying, or in Carter, they're jumping up and down saying, no, you can't do that. In McCoy, the US Supreme Court at least says that there has to be this objection that comes from the client. So I'm trying to figure out how McCoy helps you.
So I'm putting these things together but McCoy says, and this court already said this in Carter, that if an attorney is running a guilt-based defense without a client's objection, that's ineffective assistance of counsel. That's denying them, it's absolutely denying them the right to counsel.
When they made repeated and vigorous objections to the trial counsel.
If they haven't waived their right to plead not guilty. That it's never okay. It is never okay for a defense lawyer, ethically or constitutionally, to get up and tell a jury, please find my client guilty, unless the client has said, that's what I want you to do. And I'm putting it together with Johnson, where this court said, even if a client wants to stipulate to part of a crime, we're going to need an affirmative showing on the record that that's the client's decision and not the lawyer's decision. So I'm putting those things together, Your Honor. They may have had strong objections in Carter and in cases like McCoy, But when we put it together with other cases, that this court has correctly recognized that even if a client wants to partially admit a crime, we need to know that that's the client's decision affirmatively and not the lawyer's decision.
Counsel.
I see my time's up.
Counsel. Chief, if I may ask another question. If I can figure out the microphone here. You're arguing your legal premise is based on an extension of our existing precedent, if I understand correctly.
I would call it a synthesis.
But a new holding would be required. And my question is, if our existing precedent doesn't guide defense counsel to act according to your standard of care, where is that deficient performance under the Strickland standard? When you're talking about a legal premise that is essentially an expansion or new law from our court.
Well, that's why I don't think it is new law. Because I think you said in Johnson, and you've said in other cases, that in order for a person to plead guilty, there has to be an affirmative showing on the record. It's not enough for me as a lawyer to come in and say, Your Honor, I just wanted you to know my client decided to plead guilty. At some point, we have to have the defendant there in court in front of a judge saying, I actually do plead guilty, Your Honor. And you said that's true even with just stipulating to one part of a crime. So I don't think I am asking you to extend anything. I'm asking you to recognize, put Carter and Johnson together, and what do you get? You get, well, if you're going to run a guilt-based defense, which may be extremely reasonable, just like all the other things, you need to have a record made that that's the client's decision and not the lawyer's decision. And that's not present in this case.
Can I ask a question on this issue first? Assuming we do not find another grounds for reversal of the verdict, but agree with you on this issue, what is the remedy that you seek?
I think it's a new trial. I mean, the problem here, it's multifaceted, really, because it's denial of the right to a jury trial, a complete right to a jury trial. That was what was discussed in Johnson. It's also denial of the right to counsel. It's also the denial of the right to due process, because the attorney in this case is actually waiving more than the right to jury trial. It's waiving the right to trial on these issues.
Why would we not remand for clarification of the record of something that as Justice Wall pointed out, and it could be that nobody in the courtroom recognized a need to put on the record something that everybody already was aware of, might have been discussed at some point with a waiver by your client of the right?
I don't think that's the right remedy, because, I mean, it's never been recognized as the right remedy in other cases, like in a guilty plea or even in the improper waiver of a jury trial, that you sort of do a retrospective analysis of, well, would you have consented had we had this?
Or the question may be just, did you consent?
Well, she clearly didn't consent on the record. So I don't know. I mean, I don't know. I don't know what that looks like, because we don't do that in any other places where we're talking about this kind of failure to have a record of a waiver. I mean, if that's the remedy, I mean, if that's you think, I mean, again, there, and in fact, if you look back all the way, you look back at like Brady in the cases that talk about why do we do plea colloquies in the first place? It's because we don't want to get into that place of like having to look back and have a client go in and talk about, well, did I really consent to this? Is that really what I wanted to do? That those are inherently difficult processes. So it's why I think, based on your precedent, the correct remedy is to just vacate this conviction, remand it. If she wants to run a guilt-based trial in the new trial, then they'll get that on the record and they can go forward with that.
Justice Miles?
On the fifth issue, which was did the district court abuse its discretion by not ordering a mental evaluation before sentencing? How do you reconcile your argument with our recent case of State v. Evans, where we pretty clearly said it's the defendant's burden to bring this up to the sentencing court, and we don't have that in this case?
Sure, and my colleague cited Evans in its brief, and I hadn't picked up that it had been decided a few weeks before I filed my brief. So here's the difference, as I understand it. In Evans, this court said there was no evidence, for example, that Evans had any sort of mental disease or defect, any sort of psychological conditions, and that it's not the court's job to find that evidence. And that's certainly, I'm not disputing that. But on the other hand, in this case, There's a mountain of evidence regarding my client's mental disease and how it could have impacted her and how it might require a different particular disposition in this case.
That's a distinction, but the language of the decision in Evans is that it's the defendant's burden to persuade a sentencing court, which I think is kind of a preservation problem, right?
It wasn't raised below by this attorney. I agree with you that in addition to what the attorney did at trial, this attorney did nothing for my client at sentencing. I have to agree with that. But I also don't think that the district court under Evans is required to turn a blind eye to the evidence that it does have in front of it. This is different than Evans because in this case, this record shows that the district court had gone through several competency hearings, finding Rachel incompetent to stand trial because of her psychological conditions several times. So this was not a case. I mean, in Evans, the court suggested, look, if we agreed with you, Evans, we'd have to have a mental evaluation in every case. Well, I'm not asking for that. I meant saying that, well, if the district court has a mountain of evidence like this case, that it not turn a blind eye to it. That the purpose of KSA 223429, this is a poster child case for that. And that I don't think a court has to just sit on its hands, even in light of that, just because the defense attorney in this case gave up on his client. That's my best answer for you, Your Honor.
Any other questions for Mr. Hoskinson?
Thank you, Your Honor.
Thank you. Mr. Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll also focus on primarily issue 3, and will obviously be willing to answer any questions on the remaining issues. Issue 3, I first want to start by questioning whether this issue is even properly before this court. This has been raised and briefed by the defendant as an ineffective assistance of counsel claim. And as this court's well aware, those issues are generally not addressed for the first time on appeal. The defendant never raised this below, and I would argue that this is not one of the limited exceptions where an issue of ineffective assistance is capable of being reviewed for the first time on appeal. This court touched on the fact that unlike Carter, where there was evidence in the record at trial that Carter did repeatedly question and express his disagreement with some of counsel's tactical decisions, that didn't happen in this case. And in fact, I would argue that counsel is actually trying to benefit from the lack of a record showing one way or another whether the defendant expressly consented to this. The reason why we don't know whether she expressly consented to this is because she never raised the issue below. I would argue again that in those situations, in that particular situation, this is not a case that fits within this court's previous exceptions that would allow for meaningful review of an ineffective assistance of counsel claim for the first time on appeal.
Why shouldn't it be analogized to a waiver of a jury right?
Your Honor, I think that in reading through, well, and this is where, again, it gets a little bit tricky because the way that this was briefed was not a failure on the court's part. It was briefed as ineffective assistance. Now, in briefing it that way, counsel did cite to primarily Johnson and McCoy. And I would note that in reading McCoy, this case is far from McCoy. McCoy was another case where it was absolutely clear on the record from McCoy's statements throughout the proceedings, he did not want his attorney to run a guilt-based defense. Counsel ignored that and went ahead with it. And in that situation, the Supreme Court has told us that that is not the attorney's job to do if it's against his or her client's wishes. But tellingly, I think that within that McCoy opinion, the Supreme Court cites back to one of its own prior cases, which was Florida v. Nixon. And in that case, we had a situation where the attorney had run a guilt-based defense. And when the case ended up on appeal, there was a question of whether it was with or without the client's consent. And eventually that case, through a remand hearing, did come back to the district court. And what we found, or what the court found out, was that the client had basically sat silent when the attorney tried to speak with him before trial about this. Just wouldn't say one way or the other, whether he was okay with a guilt-based defense, whether he consented, whether he protested it. And in that situation, the US Supreme Court ruled against the defendant. And in doing so, they said that a guilt-based defense, where the defendant still goes through with trial, the state is still required to present evidence and prove its case, that is not the functional equivalent of waiving a jury trial, because all of the other rights attendant to a jury trial are still there for that defendant. She still maintains the right to appeal, can still argue about errors that the district court might have made. It's in that way, it is not the same as the waiver of a jury trial, right? Where all of those rights would be waived. And even unlike the situation in Johnson, where there's a stipulation, in a case like Johnson, by stipulating, the state never has to present any evidence of that element. Well, that's not what happened in this case. The state presented a mountain of evidence of the defendant's guilt. And even the fact that the defendant was on the stand testifying is proof that the state did still have to go through with the trial here. And I would disagree with my colleague's interpretation of the defendant's testimony here. When you look at that testimony, and I cited it in the brief, it's at record volume 17, pages 188 through 211. I struggle to read that testimony in any way other than the defendant admitting that she did in fact kill the victim. And the only thing that she was trying to angle for, consistent with what her attorney had argued in opening statement, was that it was not a premeditated killing. So I think that to the extent there is any ambiguity in the record about, well, she didn't expressly consent on the record, at the very least, we have her testimony in which she basically follows the same approach that her attorney did. And I find it simply incredible to believe that she would sit through an entire trial, never once complain about her attorney's strategic decision, then get up and testify in a manner that is consistent with that strategy, if in fact she had any type of an issue with this. Now, I would also, as I did cite in the brief, the unpublished Court of Appeals opinion, Reyes. And in that opinion, we had a situation where the district court spoke with the defendant on the record, both about her general decision of whether she did in fact want to testify, and also whether she was comfortable or whether she understood that the defense seemed to be angling toward a guilt-based defense. In that case, it was that the defendant was going to essentially admit possessing a controlled substance, but deny that she possessed it with the intent to distribute. And there, a panel of the Court of Appeals, in a case where the defendant then complained that the court had done that at the district court level, the Court of Appeals said, look, we know that our Supreme Court has told us that it is generally not a good idea for the district court judge to have a colloquy with the defendant about whether he or she wants to testify, because that can, one way or the other, that could potentially affect the defendant's decision in some way. And this court has consistently said that that's not a good idea. And I think the Reyes panel was correct in saying that that same theory, that same rationale, applies to a discussion about whether a defendant wants to pursue a guilt-based defense, because that is something that, even more so than just a defendant's overall right to testify or not testify, now you'd be also getting even into issues of strategy, which would be something that is generally a private decision for a defendant to make in consultation with his or her attorney. So I think that you have the same concern that you do in the colloquy about simply deciding to testify, and an added layer of concern in this case. So I would argue that to the extent this court does decide to reach the merits, that the Reyes decision is properly analyzed, and that this court should follow that logic to deny the defendant's claim. Finally, I would note that I believe it was Justice Wall questioned counsel on whether you would have to essentially extend case law or precedent in order to rule in his favor. And I would argue certainly so. Johnson, which is the Kansas Supreme Court that the defendant is relying on, Johnson was not an ineffective assistance of counsel claim. Second of all, it did involve an actual stipulation rather than a case where it's simply a guilt-based defense. And so I think it would have to extend Johnson. It would also have to extend a case like McCoy to a situation where not only is there not an affirmative showing that the defendant disagreed with counsel, but there is in fact an indication from her own testimony that she was more than fine with this strategy. And so I would argue that to the extent that this is something that would require an extension of case law, then I have a hard time understanding how defense counsel at trial could be deemed ineffective for failing to do something that had never yet been required. So again, I think it's somewhat tricky as I brief this and as I prepared for argument. It's briefed as an ineffective assistance of counsel claim, and yet a lot of the focus in the cases that the defendant cites is on whether the trial court erred in failing to do something. But I think that when you put all of the cases together, you'll see that there's not a single case that the defendant has cited in which this context, a defendant taking the stand and herself testifying in a way that is a guilt-based offense with no indication that she ever objected to this. There's not ever been a case that has been reversed on those grounds. And so even to the extent that this court somehow agrees with some of defense counsel's arguments, the remedy would be remand for a hearing. This is no different than any ineffective assistance of counsel claim, especially one that has never been raised before the district court. And in the Florida versus Nixon case that I discussed earlier, again, that was a situation where the only reason we knew that the defendant essentially refused to tell his attorney if he was on board with the defense is because there was in fact a remand hearing where the defense attorney was able to testify and explain that he had in fact discussed the strategy with his client, but his client just refused to cooperate. And so in this case, I would argue that the appropriate remedy, to the extent there's a problem, would not be to reverse a first-degree murder case, a premeditated murder conviction, on a silent record that is silent because the defendant herself failed to raise this issue below. Turning to issue 5, I don't have extensive comments on that other than saying that I think the Evans decision, which I quoted in the brief, is strongly in the state's favor. To the extent there's a difference between the two cases, I think that difference actually further strengthens the state's argument here, because in Evans, the defendant did at least file a pre-sentencing motion requesting one of these mental evaluations. Now, it appears from the record that it was a somewhat boilerplate motion and that trial counsel did not add anything to that orally when given the chance at sentencing. But even in a situation where the defendant did raise the issue via a motion, this court said that the issue had essentially been abandoned. And as Your Honor pointed out, said that it is the defendant's burden to persuade the district court that such an evaluation is necessary. And here, there was absolutely no attempt by the defendant to ever raise this. And counsel notes that, yes, of course, in a case like this, there were some questions pre-trial about her mental capacity, but those were all pre-trial. They were months in advance of when this sentencing hearing occurred. The district court was well aware of them. I think the district court judge referenced some of those issues in announcing the sentence. So this is not a situation where the district court just ignored this or was completely unaware of it. And finally, I would note that to the extent that the mental health issue was an issue before trial, ultimately, what was the result? The defendant was found competent to stand trial. And so I would argue that, again, Evans is directly in the state's favor, and that this case presents an even stronger argument that the defendant has, at a minimum, failed to persuade the court and, in all honesty, probably abandoned this issue because there was simply never an attempt to advocate for it in front of the district court.
Does it matter at all
I mean, in this case, there was a lot of evidence of mental health issues. Is it acceptable then for the court to simply turn a blind eye, that it doesn't matter at all?
I think that a district court would certainly maintain the discretion under the statute if the judge wanted, he or she could probably raise this issue sua sponte and at least consider it. But I think that in this case, the district court did that to the extent that at sentencing, the court did reference some of those issues. And so I don't think that just because the court didn't actually order the evaluation would mean that the court turned a blind eye to it. You know, if there were a statement on the record where the court had said, I don't care that there were pretrial mental health issues, perhaps that would be a different situation.
Why?
Because there, I think it would be more akin to the court saying that I am choosing not to recognize my discretion to do anything about this, or maybe failing to recognize that it even has the discretion to do so. But in this case, there's simply nothing to show that. I think that if anything, it shows that the court, again, remembered the fact that there had been some discussion or some litigation regarding mental health pretrial, but certainly didn't find anything that would have required the court to sua sponte raise this. And I note that counsel phrased it as trial counsel abandoning his client, but I'll state the obvious here. Out of the 9 of us, none of us were in the courtroom. None of us has ever met the defendant. Mr. Pittman did. Mr. Pittman is an experienced quality attorney who made strategic decisions that the defendant herself never complained about before the district court. And so I think it's a little bit harsh for somebody in this position to critique counsel in that way and suggest that counsel gave up on his client. Quite frankly, Mr. Pittman and the defendant were faced with a mountain of evidence. And faced with that, I think that Mr. Pittman did make strategic decisions in this case, and there's no indication that his client disagreed with those, and he tried the best that he could with a bad set of facts to get his client a result other than being convicted of premeditated murder. But ultimately, the facts were simply too strong, and his client was convicted as charged. But that's not a result of any ineffective assistance on Mr. Pittman's part or any abandonment of his client. It was simply the reality of this case and the good fortune that the victim's grandson proved to be a phenomenal witness who was able to not only lead police to the scene, but ultimately also provide testimony about just what happened inside that garage before he was able to get away. So for all of those reasons, and I see I'm out of time, if there are no further questions, we would respectfully ask that the defendant's conviction and sentence be affirmed.
Any questions? Okay. Thank you, Mr. Maloney.
Thank you, Your Honors.
Mr. Huskinson, you reserve 3 minutes.
Your Honor, on the first point on issue 3, I just want to make it clear. I mean, we talked about the right to counsel, but through the lens of the right to jury trial. They're not separate issues, and I briefed them as both things, citing Johnson. So this idea that I haven't even talked about the right to jury trial is not true. On the last issue, and I guess I just want to keep working on you, Justice Pauls, that there's a lot of differences, and maybe I'm asking you to, revisit Evans to some extent to recognize that this mental health evaluation is part of the PSI. That's the court's job. Now, should defense counsel have requested it? Obviously, I think so here, but I don't think that it's the court's job to do a PSI, and particularly in light of how this court has treated mental disease and defect. This court and the United States Supreme Court, following the state's urging, has said that the whole statutory scheme under 223429 is what we do today when we have really mentally ill persons who we used to might have dealt with the insanity defense, but we don't do that anymore. And so we only get to that result, though, if a judge will look at the evidence that's right in front of them. And you have to do this evaluation to trigger the options and the discretion for the judge to give a sentence other than dying in prison.
I want to focus on that for a minute, because why is that a trigger? Because the judge, both of these under 223429, the trial judge may order the defendant committed for mental examination, And then if the report comes back and shows that the defendant is in need of psychiatric care and treatment, and that treatment may material aid in the rehabilitation and society won't be endangered, then the judge, again, has discretion to commit the defendant. So number one, is there anything on the record? You keep talking about how her mental insufficiencies were apparent. Maybe the judge did consider that, but decided, the judge has discretion either before or after the mental examination.
No, for a hard 50, for premeditated first-degree murder, the sentence is hard 50.
Right.
If you get the evaluation under 2234-29 and the process goes forward, at the end of that treatment process, the judge can impose any sentence, including no sentence.
Including the hard 50.
It could have been the hard 50, but it could have been discharged.
Right, but the judge has discretion. So
but not in the current circumstances, unless
Why
the
not?
judge maybe I'm misreading. I think I've understood that in order for the judge to have the discretion under 2234-30, there has to be an evaluation under 2234-29.
Okay.
And in the absence of that, the judge would have no power. The judge had no power to do anything but sentence her to die in prison. That's the problem here.
All indications were that the judge did understand he had the discretion to order the test, the evaluation, correct? I mean, but there's nothing in the record to indicate he didn't understand he could.
He never talked about getting her evaluated under 2234-29.
Do you have any indication in the record that he didn't know he had the discretion to do that?
No, I guess, he didn't, I'm not sure what that would look like. So no, I guess is the answer to your question, but he didn't. What we do know, and that's why, I think you should be able to get to this in a case like this that would say, look, let's change this. If I had requested it, my client's attorney, appointed attorney had requested it. If this wouldn't have been an abuse of discretion, it's hard to imagine a case that would be an abuse of discretion, given the evidence of my client's mental, psychological problems. And so I just don't see what the impediment is to getting to a just result here. Thank you, Your Honor.
Any other questions? Okay. Thank you. Counsel, thank you both for your arguments this evening. We will take this appeal under advisement. We'll now call 124415 Bruce versus Kelly. Counsel, if you would please approach.
Thank you, Your Honor. I'm Alan Johnson, and I represent Mark Bruce in this case, and I would like to reserve 5 minutes of my time for rebuttal.
5 minutes is reserved. Thank you, Mr. Johnson.
Thank you. Now, this case involves two issues of Kansas law, which the United States District Court of Kansas, which is a federal court, certified or referred to this court to decide because they could be determinative of the claims that are in federal court. And I want to begin by explaining the context of these issues and what the federal suit involved, because the federal lawsuit is somewhat complicated. Now, Mr. Bruce is the former superintendent of the Kansas Highway Patrol, which is the highest officer or the agency head of that state agency. Now, Mr. Bruce started with the Highway Patrol in 1989, and he worked himself up through the ranks until 2008 when he was appointed a major. Now, a major is right below the assistant superintendent and the superintendent. So the way the Highway Patrol is organized, superintendent is at the top, assistant superintendent is next in line, and then at the time that Mr. Bruce was a major, there were 4 majors underneath the superintendent and assistant superintendent. Now, when Mr. Bruce was appointed major, he served a 6-month probationary period as required by the Kansas Civil Service Act. Kansas Civil Service Act is a comprehensive act, a state law, which governs the employment relation between all employees of the state and the state. Now, After serving his probationary period, Mr. Bruce became a classified employee with permanent status under the Civil Service Act. Now, the Civil Service Act has two categories of employees. One category are unclassified employees. Those employees are employees at will. They can be terminated at any time for any reason or for no reason. They have no job protections. The second category are classified employees, and those employees have certain job protections by statute, the Civil Service Act, most importantly, that classified employees cannot be terminated from their positions without just cause. And if they are terminated, they have a right to a due process hearing in front of the Civil Service Board to contest that. And that's why there are due process guarantees that they're given. Now, Mr. Bruce served as major, which was then a classified position, until 2015. At that point in time, then Governor Brownback appointed him to be the superintendent of the Highway Patrol. The Highway Patrol, the superintendent, other employees of the Highway Patrol are governed by a state statute, which is 74-2113, and that's really the statute that is at the heart of this lawsuit. Now, that statute provides that the superintendent and the assistant superintendent are unclassified. That means that they serve, the superintendent serves at the pleasure of the governor and can be removed at any time for any reason or no reason. The statute also provides that if a person appointed as a superintendent is a member of the Highway Patrol when appointed, that person shall be returned to a rank no lower than the rank that the person held when they were appointed as superintendent. Now, Mr. Bruce.
Counsel, way over here.
Oh, sorry.
Yeah. Since you mentioned on that part of the statute, maybe I didn't mean to cut you off short, but the 74-2113 subsection A speaks of once the unclassified term expires or terminated, then they shall be transferred to the last rank they held prior to appointment to unclassified service. Can you explain to me how you construe the term rank and whether or not it's analogous or identical to a position or permanent status? You know, because the Kansas Civil Service Act uses, permanency and the term position. This other statute that you talk about, 74-2113, protects rank. And I don't see any statutory definitions. I'm wondering what your definition is.
It's my contention that rank and position are the same thing. Rank is used in the Highway Patrol because it is a paramilitary structure, so that the superintendent is actually a colonel, the assistant superintendent is a lieutenant colonel, and then the next position or rank are majors. And so in that particular agency, positions are described by rank. So my contention is they're the same.
Yes, but superintendent is a position that is also designated a rank of, I can't remember, did you say colonel? Or?
Yes, colonel.
Colonel, my apologies. And then assistant superintendent is a position, and it's also a position that can only be held by, I'm sorry, what's the next rank?
Assistant superintendent.
Well, assistant superintendent, but it can be held by what rank?
Colonel.
By lieutenant colonel, right? And then we go to major, and there's no corollary position assigned to major in the statute like there is for a superintendent or an assistant. So do majors perform different jobs at the Kansas Highway Patrol, or is major a job?
Major is a job, but they are in charge of different troops. And so each major has different kinds of assignments. Now, those assignments are not determined by statute, they're determined by the agency itself. So my position is that when the statute refers to, and it's not transferred, the statute said that a person shall be returned to the position that they held before, that means the same rank. Now,
and can I ask you one follow-up
Sure.
question? I'm sorry, because you reminded me in your last comment that the statute does use the term returned. My question is, under the Kansas Civil Service Act, there's also a term of art that is a defined term of demotion. So can you tell me why returning from the position of superintendent, the highest position within the Kansas Highway Patrol, to the lower rank of major does not fall within the statutory or regulatory definition of a demotion under the Kansas Civil Service Act?
well, excuse me, there are two reasons. First of all, the 74-2113 is a specific statute that applies only to the Highway Patrol. The other statute that you're referring to, which is part of the Kansas Civil Service Act, is a general statute that applies to all kinds of agencies. And one of the rules of statutory construction that this court uses is that a specific statute should control over a general statute. That's one reason. The other reason is that 74-2113 uses the term of art, which, as you said, Justice, these are terms of art. And in the Kansas Civil Service Act, actually in the regulations that implement that act, the term demotion or transfer are specifically defined. But the statute, the specific statute that applies to the Highway Patrol, uses the term return. Now, return, the general dictionary definition, means to go back, to be restored to that position, so that being restored to that position is not either a transfer or a promotion because it's specific to that statute.
I think the federal court here, this is the biggest mess of statutes that I can remember. This just doesn't make sense. And you have arguments using the text of the language, and counsel does, which I think, especially with what the federal court said, tells us that we've got to go into the minefields of legislative history. Here's the one piece that's stuck out at me. And I hate going into legislative history. I'd rather stick with the language of the statute. But when your client is testifying to the legislature, and I noticed the testimony was both at the House and the Senate, the purpose of making the change, the 2018 change, was to make sure that majors were protected from termination. And that specific word, I think he used the word firing in one of the legislative bodies and termination in the other. And as much as you can compare these statutes to the KBI and to the Department of Health and all that, and in the end, it seems to me the legislature had plainly in front of it that if you pass this law, it's going to protect majors from being fired. What do you, I assume you agree with that?
Yes,
because it helps
yes.
you, but it also takes away from some of this fighting about whether the word return can mean something different for the Highway Patrol as opposed to real people. But aren't we just stuck with legislative history, I guess, is my bottom line here. As hard as you're trying, both of you, to make the words work in the text.
Yes, we're stuck with that, but even though it was my client's testimony, I don't think it is crystal clear what he was trying to explain to the legislature. At least Judge Crabtree didn't understand that. Let me tell you what I believe he was trying to tell them. That was when the Highway Patrol adopted a comprehensive compensation plan in 2018, it required the majors to voluntarily move out of their classified position to an unclassified position so that they were not subject to the state pay plan, and they could make more money. And that was the reason that they did that, but it was not an abolishment.
I mean, I don't want to get too far off the facts because we're stuck with the questions posed by the federal court, but that made no sense to me either. that the superintendent's just coming in with a pay plan and department administration, and I didn't believe you when you said the legislature approved this. All they did was approve a budget. They didn't approve these change in ranks and so. Why did it require the majors to give up their classified status? That's what didn't make sense to me.
Because if they're classified, they're governed by the state pay plan, and that caps them at how much they could make at the level that they were on the state pay plan. Now, unfortunately, the only reference to the comprehensive compensation plan, it is Mr. Bruce's testimony to the legislature. It's not part of the record, and so it's not clear. His contention, my contention is that they voluntarily left their positions to an unclassified position, but that did not mean that the position itself was unclassified.
How do we get there, given what does seem to be about as clear of two sentences as there might be in all of this? And granted, they're separated by about 3 sentences in between them, but I still think logically they seem to link, and that is the one sentence that says the superintendent and the assistant superintendent are unclassified. And then the second sentence that says all other officers, troopers, and employees shall be, I've got it backwards, shall be within the classified service. So,
right. It's my contention that what that means is that the majors are included in that last sentence, that they are in the classified position. And it's also my contention that neither Mr. Bruce nor the legislature could constitutionally declassify the major position because of this court's decision, 1989, the Darling versus Kansas Water Office Act. Now, in that case, the legislature passed a law in which they declassified several positions in the water office and directed that those employees be fired. And this court said that constitutionally, the legislature could not do that the statute was unconstitutional because it violated the 14th Amendment, because once the state grants a property interest in employment, which a classified is, that cannot be deprived. They cannot be deprived of that without some due process procedures.
and I think that all probably falls back to the federal court to sort out. But how can they be classified for some things and maybe not classified for other? I mean, if they voluntarily took that step, do we accept that, or do we say no, the statutory language trumps?
Well,
or is it kind of sort of maybe for this purpose, but not really good for that purpose?
I think they are entitled, an employee who is in a classified position can leave to go to an unclassified position, generally because they can make more money, they're not capped, but they give up all the job protections. In unclassified, they're employees at will, and they can be fired at any time. So in this case, all the majors said, when this act was passed, we're going to go to the unclassified. Some of them could have stayed in the classified. If they stayed in the classified, they could not be terminated without just cause. The ones that did go to the classified, when they were in the classified, could be fired at any time for any reason or no reason.
Counsel, I have a question about the second certified question.
Yes.
And since we're discussing ambiguities, to me at least, there's 2 plausible ways to understand the question from the district court. The first way to understand it is the district court is asking us, as a matter of Kansas law, to interpret the language of KAR 1-7-4. In other words, what does the language used in the regulation actually mean? But the second way we could interpret this question is, does the executive branch have the lawful authority to promulgate this regulation in the first place? Can you shed any light on how we should interpret the question from the district court?
Well, I think in a certified question case, you have very broad authority in determining what it is the federal court is asking you.
Well, I'm asking you what you think the federal court is asking.
I think the federal court is asking, the first question is, does what does this regulation mean? Not necessarily that he is asking, is this regulation permissible?
And then the follow-up question, because you've made the argument that if this regulation means what the state says it means, that it's impermissible, essentially. The executive branch doesn't have the authority to contradict statute. You've made that argument.
Well, yes.
And so I guess my follow-up question is, in a certified question case, is our answer limited by the scope of the question?
I would say not necessarily. Let me tell you what I think the federal court is asking and what the answer should be. The answer should be that the regulation does not apply in this case at all, because the regulation talks about transfer or demotion. And Mr. Bruce was not transferred or demoted under 74-21-13. Once his term as superintendent ended, he was, by statute, returned. He had to be returned to his former position. Therefore, my argument is that the regulation has no application to this case, and that Mr. Bruce would not have to serve a 6-month probationary period when he went back to being a major, and he went back to being a major with permanent status, not in the probationary period, which frankly he could be terminated from his employment as a major for any reason.
If that's your argument, as I understand it, that the return language in 74-21-13 differentiates you and kind of carves you out of the Civil Service Act, I want to point you to and have you address the other statutes, like the KDHE director statute, the KBI director statute. They were former versions of that statute, and still the acting officer statute at 75-43-15. Very similar statutes, just addressing different types of leadership positions in the executive branch. And in those situations, either in the past or in the case of the acting officer statute, currently, the legislature chose to use language that expressly protected the permanent status of the secretary that was returning to the former position. And that language is not in 74-21-13. Can you answer to me why that wouldn't matter, or how would you respond to that argument that the legislature knows how to specifically protect a permanent status or permanent position?
My argument is I believe that the statutes that you refer to that have more express language were passed after the original version of 74-21-13, and that when 74-21-13 was passed, they used language at that point in time, which was that the superintendent would be returned to his position that he previously had before that. I think since that statute was enacted, I think the legislature and the executive branch have fought over permanent status of various administrative agency heads. And so the legislature wanted to make clear what kinds of positions were protected and which ones weren't. But when 74-21, the statute that applies to the Highway Patrol was enacted, that wasn't necessarily an issue. So that's why there is a difference in language there. But I will concede that, frankly, from my client's point of view, I wish the statute 74-21-13 had that language in it. My argument would be a little bit stronger.
Going back to that legislative history where, so first of all, this the 2118 legislation was advocated by the Highway Patrol.
Yes.
They wanted this thing.
Yes.
So this is their language. And so, yes, we know the legislature, knew how to do it right. Let's just say that. It wasn't didn't come up apparently. But we still have this language in the legislative history that I can't resolve, which is the superintendent saying this is to protect majors from being fired when they're no longer majors.
Yes.
Because that's otherwise what would happen.
Right.
That seems to be the clearest thing of anything that we have in this deal.
Except for the context that is that they had voluntarily, under the compensation plan, chosen to get out of this classified position, that it was a voluntary move on their part. It was not an abolishment of the classified status of being a major. And again, I go back to the Darling case, which is even assuming Mr. Bruce and the legislature had done that, they could not constitutionally do that under this court's decision in the Darling case and what happened in the water office agency dispute. I'm out of time, so unless you have any other questions, I will pass the baton to Mr. Cooper. Thank you.
May it please court. Again, David Cooper appearing on behalf of the governor, the Honorable Laura Kelly, her chief of staff, Will Lawrence, and KHP Superintendent Colonel Herman Jones. Again, I know the court's aware of this, but with respect to the audience and those watching, the facts underlying this case is, again, that Mark Bruce was hired as a trooper in 1989. He achieved the rank of major in 2008. In April of 2015, then Governor Brownback appointed Mark Bruce as the superintendent of the Highway Patrol. Governor Kelly was elected in November 2018 and took office in January 2019. And then in March 2019, the chief of staff told Mr. Bruce that he needed to resign. And Mr. Bruce elected to resign and retire at that time, drawing a full KPNF pension based upon his retirement at the rank of the colonel as superintendent of the KHP. And that has practical effects and practical meanings. One, if you retire from the KHP, as opposed to resign or get fired from the Highway Patrol, you're entitled to draw your accrued vacation up to 240 hours under Kansas statute. Also, when one retires from a KPNF organization under the state, whether it's a state level, KBI, Highway Patrol, the fire marshal, or any of the local units of government that elect to be under KPNF, a person can retire after 30 years of service with 50% of their salary, or their final average salary. And so it makes a difference what your salary is when you retire. Mark Bruce now sues the governor and chief of staff, asserting several employment claims that are predicated upon the court's suggestion that he had a property interest, that he had an interest in continued employment by the state of Kansas for a definite term. And under Kansas law, under Stolt versus City of Toronto, the default under Kansas law is unless the Constitution or a statute specifies one's term in office, one is an at-will employee and it could be terminated at any time by the appointing authority. Now, Mr. Bruce asserted there were three claims that he's asserting. One against the governor in her official capacity for deprivation of due process, one against Mr. Lawrence in his official capacity for deprivation of due process, and one under state law for a claim of deprivation of a prospective business interest, meaning he had a right to a job with a state following the termination of his term as a superintendent of the Highway Patrol.
I mean, what you're talking about is what Judge Crabtree is going to be addressing, but when we get a certified question from the federal court, we have to be laser focused on the question. So the first question is, does the statute define the rank of major as a member of the unclassified or classified service?
My answer to that is it does neither.
and why?
Okay. What 2113, 742113 does is in the prefatory sentences, the initial sentences, it specifically says that the rank of superintendent, or the position of superintendent and assistant superintendent, and the ranks for those two people are the colonel and the lieutenant colonel, shall be members of the unclassified service. Then the statute goes through and it talks about what happens when the superintendent and assistant superintendent, and then under the statute as amended in 2018, the majors, when their term ends, they may return to the rank they held when they were appointed to the rank that they are termed from. So this, with respect to the circumstances of Mr. Bruce, he was a major at the time he was appointed superintendent. Under the statute, he would be entitled to return to the rank of major, assuming he didn't resign or retire voluntarily. And he claims in this case to have been constructively terminated. The statute then concludes, after talking about what doesn't happen with a superintendent, an assistant superintendent, and a major, and then concludes all other employees are part of the classified service. So to the extent it speaks to who is in the classified service, it's everyone other than the lieutenant colonel, excuse me, I said lieutenant, the superintendent, the assistant superintendent, and the majors, all others other than that rank. Otherwise, the amendment doesn't have any purpose at all.
Counsel, but that's not what the statute says. I mean, that's not the language of the statute. The statute says that the superintendent and the assistant superintendent are unclassified.
True.
And you just said superintendent, assistant superintendent, and major. And so how do you get there when the statute says superintendent and assistant superintendent unclassified, everyone else classified? And that's pretty straightforward, plain language, even though, as Justice Lukert noted, those sentences are separated.
Yeah, and that is my point, is that that last sentence, all other positions shall be unclassified, has to be read in context with the statute as a whole. And
but what
again,
what could those words "all other" be possibly referring to, other than the sentence that says superintendent and assistant superintendent are in the unclassified service?
it would be referring to the positions in the preceding two sentences where it speaks to the superintendent, assistant superintendent, and the majors.
Would you agree with, well, let me put it this way. It appears to me that those intervening sentences aren't actually talking about classified versus unclassified at all. They're talking about this whole idea of hire, return, that's a separate question from classified, unclassified. Wouldn't you agree with that?
In context of the legislative history, and I know Justice Biles hates to have to get to that point, but in terms of the context of how this statute came to be and how that amendment came to be, and the recognition of by the legislature of the changes that occurred in 2016 and 2017, that no, the major positions, the 5 major positions were in fact declassified.
So if we don't go to legislative history and just stick with the language of the statute, do you have any argument that the intervening sentences where it talks about majors is discussing classified versus unclassified? Because just as I read the sentences, it's talking about when they get terminated, they have to go back to their old rank.
Well, it would be also then to resort to statutory construction and to assume that the legislature is not amending a statute for no reason. And the 2018 amendments don't mean anything if you don't read them to understand that the position of major is not classified.
Why would we go to canons of instruction if the plain language of the statute is plain and unambiguous?
Well, as Judge Crabtree noted, you can read this statute one of a couple of ways, and both of them are reasonable. And so given that there are two reasonable constructions of the statute, you do attempt to derive the intent of the legislature. And when you go to the legislative history and legislative intent, again, the amendment does not make sense and has no purpose unless the majors are not classified.
Well, counsel, doesn't the amendment, even under the opposing construction of the statute, we still have meaning to the 2018 amendment because it adds major to the list of positions that have a right to return to their former position.
And maybe I'm not being clear enough. If major is a classified position, you can't be terminated or demoted from it without cause in the first place.
Isn't that different though than the right to return to your former position?
No.
I want to know if there's any protection under the Civil Service Act that guarantees a classified employee the right to return to their former position. That seems like a very distinct set of rights than the right to return that's outlined in this 74-2113.
The right to return to a position is a defined matter. So if there are positions that are here, it would go from lieutenant to captain, captain to major. And with respect to ranks, we're going to stop there because the other two are clearly unclassified. But once you occupy that position, the demotion from captain to lieutenant or lieutenant to a lower level, all of those carry Civil Service Act protections. Once you achieve permanent status in a position, demotion from that position carries with it all the same due process protections. So again, if you're talking about if the major were a classified position, you're reading. Well, it's superfluous to say they have that protection in the statute.
Well, before the 2018 amendment, did a major have a right, if whatever the class below major is, they are promoted to major, does the Civil Service Act provide them a right to return to their former position?
Now I have to go back before 2016 in order to answer your question, Justice Wall, because in 2016, those positions were declassified, but let's put it before 2016 so that we're talking about apples and apples here. The answer is yes. Prior to the declassification of the positions of majors, once you had achieved the rank of major in the classified, achieved the rank of major, completed the 6-month probationary period, you had a property right in the rank of major and due process protections for removal from that position, whether it was removal meaning out of state service altogether or demotion to a different position.
So, but I guess my point is, having the protection of not being able to be fired without just cause, let's say to simplify it, that just seems different to me than the right to go back to your old job. How are those the same thing?
They're not.
Right.
And that's why I answered the first question is, it does, the language about returning to a rank is not a determination of whether a given position is or is not in the classified service. And
but doesn't that, I mean, what you just said, go against your whole argument? And well, I'll leave that question because I have a question. You are saying in 2016, the position of major in the Kansas Highway Patrol was declassified.
yes.
Okay, and how did that happen?
Mark Bruce declassified it. He was the appointing authority, and under the statute 75-29-35, the appointing authority has the ability to declassify a position, and the legislature recognized that in the manner in which it was funding the positions. And when you track through the budget documents, the number of budgeted positions for Classified individuals versus unclassified individuals changed by 5. 5 positions became unclassified, and the number of unclassified positions
That's your
increased by 5.
position, though, but opposing counsel would disagree.
Well, it's reflected in the budget documents approved by the legislature.
So anytime the legislature passes a budget, then a position can become classified versus unclassified.
Anytime the appointing authority declassifies a position under the statute, and then the legislature approves the budget that achieves that declassification, yes.
Those majors signed voluntary relinquishment of their classified position, which doesn't make any sense to me, but that's neither here nor there.
But
the 2118 legislation was designed to fix this circumstance that had occurred because these majors voluntarily gave up their classified service.
Right, and then there was not a statutory mechanism that allowed them to return to a prior rank.
So let's go back into my legislative history problem. Believe me, I don't want to be there. But it says in here that it tells the legislature, you need to pass this legislation so that these majors, when they roll out, can't be fired. And so that's what if we're trying to find the intent of the legislature, it's pretty plain to me out of all of this that that's the one thing they understood in passing this piece of legislation that's got a lot of other conflicting language that brings us here. How am I wrong in looking at it that way?
Because if the position is unclassified, if you have left the classified civil service, once you re-enter the classified civil service, you must complete that 6-month probationary period. And I know that's a second question, but that's still the answer to the question.
Right, but I think this is the answer to the second question because that's not what this legislation was supposed to do. This legislation was supposed to protect these people from being terminated if they were moved out of their position, which tells me they're not supposed to have this probationary period because otherwise they're terminated. They can be terminated. And this was to protect these officers from termination.
And that goes to the statute, the 75, sorry, it's the one that Justice Wall cited earlier with respect to the specific language.
2925.
Right. In the 5944, with respect to when they want somebody to return back to the classified service, they say that, to come back to the classified service, because there are limited positions where somebody can leave the classified civil service, accept an unclassified position, and then go back to a classified position.
And I'd be happy with that answer if there was some indication in the legislative history that they changed the language or did something about the language to make sure that these people weren't having to go back to the period of probation where they can be terminated, because the mission of this legislation is to protect those people from being terminated. I just think they didn't use the right language, and we've seen a lot of language here that shouldn't be here. That's why I think we have to get to legislative intent. And that's why we're here.
And as applied to Mr. Bruce, there is no question that he left the classified service. And when you're talking about the change of majors from classified to unclassified, that was a new thing that occurred when they changed the pay plan, expanded and they had to move them out of the state pay plan to get them to get their salaries to a level that was commensurate with the responsibility.
What happened to the majors in 2016 as they voluntarily moved out into unclassified, and then I assume as part of the 2018 protections were back into classified? Is that what happened?
So, ask that again.
In 2016, there was the majors that existed at the time moved out of a classified to unclassified to receive a higher pay rate. Is that what happened in 2016?
Yes.
And then what happened as a result of that when those particular majors were then put back into the classified? And I assume in 2018, or were they ever?
That's the deal. They were never, and none of the people who were there then are majors now. All of the people who hold the rank of majors have attained that rank since 2018.
Okay, so they were never returned to a classified status.
Correct.
Okay.
And is it your position that the current majors are classified or unclassified?
Unclassified. And they knew that when they accepted their positions.
I want to return real briefly perhaps to the 6-month probation period and the regulation. If I want you to assume for the purpose of my question, and it does appear to be the case, to me at least, as I read the language of the regulation, that the regulation is written in such a way to require a 6-month probationary period, even upon a return to the classified service.
True.
So assume that is this court's view for the purpose of my question. Is the follow-up question actually in front of us, which is, does the executive branch have the authority to promulgate that regulation in the first place? Or put another way, would that regulation conflict with the statute? Is that question in front of us?
I believe the answer is yes.
So you think that that question is encompassed in the district court's certified question to us?
I am, because it's, and giving credit to my colleague's arguments, is that the regulation itself is an unauthorized regulation because it conflicts with the statute. And my answer to that is no, it doesn't conflict, because the statute doesn't speak to classified service or not unclassified service. So I guess
you're not here trying to prevent us from answering that question.
No, I'm not. And I believe the I believe the question answers itself. The regulation says what it says.
Can you provide me? There's just the plaintiff here completed his probationary period back in when he was promoted to major, and I think that was in 2008. What is the purpose of him redoing that when he's already satisfied that obligation, or the purpose of completing a probationary period? And I know, I mean, even if we arrive at yes, he has to do it, but why? What's the point?
The best I can answer that question is from the context of the statute, which is whenever you move from any position in state employment to another position in state employment, you shall serve a 6-month probation.
And the point is that you demonstrate the competence to be able to handle the particular responsibilities of the position, and he's already demonstrated that, and even then served in the capacity up until he was appointed superintendent.
Demonstrated competence to the satisfaction of the appointing authority, and which would enable the appointing authority in the circumstance to conclude within that 6-month period, no. So, and again, does the legislature have the authority to promulgate that regulation? They do, they did, and here it is unquestioned that Mr. Bruce left the classified civil service for a period of 3+ years, over 3 years, and again, he never returned to the rank of major. We need to understand that. But the relief being requested is to be returned to the rank of major in the classified civil service with permanent status. And given whatever we want to talk about, those positions aren't in the classified civil service, and he's not entitled to permanent status at that rank.
Any other questions? Thank you, Mr. Cooper. Mr. Johnson?
Thank you, Your Honor. I had 2 points I wanted to make clear. One was that as to the argument that Mr. Bruce declassified the position of major in 2016, I really have 2 alternative arguments. One is, which I argued earlier, is that that cannot constitutionally be done because of this court's decision in the Darling case. Now, my alternative argument is that the 2018 amendment was designed to give the majors job protection. It goes back to your question, Justice Biles, what was the purpose of the 2018 amendment? And the only evidence of legislative history is Mr. Bruce's own testimony before the legislature. And in that testimony, I think the key sentence there is, he says, in fairness to our majors and in the best interests of the patrol, I'm requesting that their position be afforded the same earned protection. And the legislature agreed with that, made the change. So the purpose of the change was to give the majors job protection, meaning that they were classified and could not be terminated without just cause. And if they were terminated, they would have the right, due process right, to go to a hearing in front of the Civil Service Board to contest that.
Mr. Johnson, your opposing counsel mentioned that the 5 or 6 majors, I'm not clear from the record whether there were 5 or 6, back in 2016, did they sign something waiving?
Well, that's not clear from the record. And that's one of the problems about how this case came up to you, because in the federal court, we're at the motion to dismiss. So that is not clear from the record. It's Mr. Bruce's contention that they voluntarily went out of the classified into the unclassified. Now that, when we get back to federal court, that can be developed through discovery, and we'll find out what that is. But that is unclear from the record at this point, and is not in the record, frankly, at any point. Now, the second point I want to make is, does the regulation, KAR, the one that the defendants rely upon, does that regulation requiring a 6-month probationary period conflict with 74-2113? My contention is that yes, it does. And the follow-up question, is that issue before this court? And my answer is yes, it is before the court, because I made that argument to the federal court. The federal court, in its 61-page opinion and some footnotes, addresses that argument. And so that argument and issue is clearly before the court, and I believe you have the authority in answering the certified questions to address that issue, because if it's argued to the district court, he addresses it, and it's part and parcel of the issues, the 2 issues that the court asked you for guidance on. So unless the court has any other questions for me, I will not use the rest of my time. Thank you.
Thank you to both counsel for your arguments this evening. What I say in tradition at this time is that the court will take this matter under advisement. For the benefit of the audience, I'd like to give you a little bit of explanation of what that traditional line means, which is that the next step is that the court will meet and talk about this case. With the 7 of us will have discussions about what we believe the outcome of the decision should be. From there, 1 or more justices may end up being assigned or electing to write an opinion, because there might be one opinion, there could be several opinions that are generated from the case. But that writing will occur, and once the writing is done, and actually along the way, there could be more times that the court meets to conference and discuss the case. But once there is something in writing, each of the justices then reviews those writings, and through all of that process, we finally come to a point where we file a decision, or multiple ones of us filing a writing about where we come out on the case, and that is filed with Mr. Shima's office as the clerk of the court and becomes an official record of the court. It also is something that is published and is posted on our website, kscourts.org, so that once this is all finished, you will be able to go to our website and read about the 2 cases and how those come out. We will also be issuing press releases when those decisions are filed, So you'll be able, through the news, be able to know what those decisions are, and just to remember that they are available for you to read if you so choose through that website. With that, we thank you for attending tonight. We appreciate your patience, and we look forward to visiting with you out in the entry area in just a few minutes. So thank you again. With that, court is adjourned.
All rise.